Hey guys, welcome to my legal classes. This is Ganesh Pujari and I hope you have already gone through my introduction session on trials. Now in this session I am going to discuss trial before a court of session, which is discussed under chapter 18 of CrPC from section 225 to 237. Now I have two slides, one which is very easy, which I am telling like a story, and the next slide will have little detail on the same chart. Now let's get into the first chart to understand the concept easily. This is one of the most important chart as far as trials are concerned. Now this chart belongs to session code. However, you can almost copy the same for the warrant cases as well as summon cases. It goes with a similar line with few changes here and there. Now I have two slides. One, this slide where I have very less information put in because I want you guys to grasp the image. In my next slide, with the same chart, I have given more information under each section. Now, the entire prosecution starts with public prosecutor as per section number 225. Who is a public prosecutor? In every case, there are two parties. One is victim, the other one is accused. The public prosecutor is the advocate who is appointed by the government to fight for the victim, whereas the victim will have his own defense counsel. And in any case, if he doesn't have sufficient means to have his own defense counsel, that means if he doesn't have that much money, he can request the government or court to give him a defense counsel at free of cost. That will be arranged. Now, such public prosecutor will open the case with his open statement as per section number 226. And once after hearing that open statement with the charges and evidences, court will decide whether to take this case further or not. If the court is convinced there are no sufficient things to discuss in that particular case, it can discharge the case and discharge the accused in section number 227 itself, and the case comes to an end in the second section itself. Whereas if the court feels there are sufficient grounds, then it can frame the charges as per section number 228. After framing the charges, the court will ask the accused whether he will agree the guilty or he want to trial. Now, if he agrees the guilty, then as per section number 229, conviction on plea of guilty will be made. However, if he rejects, then the trial continues with section number 230, where court gives time to the public prosecutor to bring all the evidences. Once the evidences are brought under section number 231, the court will decide whether to acquit the case or take it further. If it decides to acquit the case as per section number 232, the case comes to an end. However, if the court would like to take it further, then comes the entry of the defense counsel, which is under section number 233. Remember, from 225 to 232, it is all public prosecutor and the court, and at 233, the defense counsel enters for the first time. After defense counsel statement, 234th section is discussing all about arguments. Once after the completion of argument, court will give its judgment whether acquit the case or conviction. After such judgment, the court will see if there is any previous conviction, which is only after proving the conviction in this particular case. That is the brief. So to open the case, discharge. If not discharged, framing the charges, then convict. If not convicted, then date for evidence and then see the evidence, then acquit the case. If it is not acquitted, entry of defense counsel, then the arguments, then the judgment, and then see the previous convictions. Now I am going to tell the same story in little detail in my next slide. Now that you have a brief idea, I am going to tell the same story with little detail here, and once you complete listening to this particular part, I think you need not to study any further because you will be knowing all the aspects. Now section 225 is very easy. As I said, the entire prosecution starts from the public prosecutor who is fighting for the victim. Now 226, he is making the opening statement. Public prosecutor makes the opening statement about the entire case with description of charges as well as the evidences that he is having. After listening to him, the court will decide whether to take this case further or not. In any case, if the court feels there is no sufficient ground to take it further, it discharges the accused as per section number 227. However, if the court feels there are sufficient grounds, then it frames the charges and decides whether to continue the same in the session court or give it to Chief Judicial Magistrate, which is lower court. And if at all it decides to continue the same matter in session court itself, then it asks the accused whether he agrees the guilty or he wants to trial. It will also give the details of all the charges to the accused. Now, section number 229 is the opportunity for the accused to agree the guilty or agree the offense that is being accused on him. However, in that case, if he doesn't agree, then comes section 230, where the date for prosecution's evidence will be given. That means public prosecutor has to provide all the witnesses that he has told in the opening statement as per section 230, and to help him, the court can compel the witness document things. That means whoever is being asked to come as witness from the public prosecutor, or whatever documents are requested or whatever things are requested, will be compelled by the court to bring on certain date and time. Now, section 231, the court will see all those evidences, witnesses, or the documents, things whichever is brought by the public prosecutor, and it also gives an opportunity to the defense counsel to cross-examine the same. Now, after this level, if court feels there is nothing much involved in this particular case, it can acquit the case, and while acquitting or while discharging that case, it needs to record the reasons for its decision. However, if it continues the case thinking that there are sufficient grounds to take it further, then comes the defense counsel at section number 233, where they will make their statement, maybe in written also, and they can call the witnesses, record things again. But court will decide which witness to bring back, which records to bring back, or which things to bring back based on the timeline. If the court feels that the defense counsel is simply wasting time, it can deny bringing any of the witness, records or things to ensure that justice is prevailed. Now, section 234 is all about arguments, and finally, after the conclusion of all the arguments, prosecutor will sum up the entire arguments. And section 235 is the judgment by the court. It can either acquit the case or convict the case. If it is passing any decision, judgment, order based on the conviction, then it needs to observe the provisions given under section number 360, which is probation, that is for the first offenders. Now, section number 236 discusses about previous conviction, and one important point you need to remember while discussing about previous conviction is previous convictions will be discussed only after such person is convicted for this particular case. If he is not convicted, then there will be no discussion on previous conviction, or while the arguments are in progress, there cannot be any discussion on previous conviction. That is one important factor you need to remember. What about section 237? Section number 237 discusses about the provisions against section 199(2), which is discussing about defamation of president, vice president, governor, etc., which is not very important in this particular chart, so I have not brought that in this particular chart. Now, if you can remember this chart beautifully in your memory, then you can almost copy paste the same in warrant cases as well as summon cases. However, in my playlist I have videos on that also. Please go through them for more ideas. That brings an end to this particular session, and if you have not understood after those two charts, then there is some serious problem with me, because there is no easy topic than this to teach. Thank you so much for all your comments. Thanks for subscribing my channel. Please like, share and comment my videos. All the very best for your exams, and thank you so much for watching me.